Good afternoon again. I'm Mark Matson, committee staff. And with me from the Community Safety Committee is Corey Patton, if there are questions about the criminal aspects of this bill. So just FYI. This bill concerns accountability for persons for speeding. And so I'm going to go through some background. It's going to take a little bit, and then I will get to the summary of the bill. So the Department of Licensing, they issue regular driver's licenses, but of course they also issue other specific driver's licenses as well as restricted driver's licenses. So one of those driver's licenses that is special is the ignition interlock driver's license. And this may be issued when the person has been convicted of impaired driving under one of several criminal statutes. Under the terms of the license, a person may only drive a vehicle equipped with a functioning ignition interlock device into which the vehicle operator has to blow to verify that the blood alcohol content is below a certain level before the vehicle may start. Under the terms of the license, an ignition interlock device must be installed on all vehicles operated by the person with certain exceptions, and it must remain in place during the license suspension, revocation, or denial period. In addition, a court may order the use of one of these devices as a condition of pretrial release of a defendant or as a condition of post-conviction probation. An ignition interlock user must pay the cost of installing, removing, and leasing the device unless the company waives the costs or the person is indigent. In addition, the applicant must pay a $100 application fee and a $21 monthly fee to the Department of Licensing, which then deposits these funds in the ignition interlock device revolving account, expenditures from which are used to offset the cost for indigent persons. If the device is removed or stops functioning, the person's license will be suspended until the device is reinstalled. It is a gross misdemeanor for a person to drive a vehicle without a properly installed device or for the vehicle operator or another person to tamper with the device. These devices are not required on an employer's vehicles that are driven by the convicted person when driving the vehicles as a requirement of employment during working hours. Now, a little bit about traffic laws relating to excessive vehicle speed. As most of you probably are aware, a driver who operates a vehicle in excess of the posted speed limit commits a traffic infraction with certain exceptions, and the person is subject to a fine which depends on the magnitude of the speed in excess of the speed limit, and the fine is prescribed under state court rules. Another type of offense is called racing, and this is the comparing or contesting of the relative speed of one or more vehicles. This type of illegal conduct constitutes reckless driving. An exception to the infraction rule is a driver following a slow-moving vehicle on a two-lane road may pass the vehicle at a speed that exceeds the speed limit, but only at such a speed and for only such a distance as is necessary to complete the pass with a regional margin of safety. Now, a little bit about suspensions. A person's driver's license may be suspended by the department for a number of reasons relating to the violation of the law, two of which include an accumulation of too many moving violations and a criminal conviction for reckless driving. While the penalty for a single moving violation is a fine that varies according to the severity of the offense, an accumulation of 3 or more moving violation infractions within a 1-year period or 4 or more such infractions within a 2-year period results in a suspension of the person's driver's license for a period of 60 days. In addition, the department must establish a period of probation for 1 calendar year to begin when the suspension ends. During the period of probation, the person must not be convicted of any additional traffic infractions for moving violations. If there is such a conviction, then there will result in an additional 30 days added to the suspension period. A person who drives a vehicle in disregard to the safety of people or property is guilty of reckless driving, a gross misdemeanor punishable by imprisonment for up to 364 days and a fine of $5,000 or less. In addition, the department must suspend the person's driver's license for at least 30 days. Now a little bit about intelligent speed assistance devices. An intelligent speed assistance device, I'm going to call these ISA devices, and they're colloquially known as speed limiters, is a technical device designed to be installed within a motor vehicle to actively monitor and prevent the driver from exceeding a preset limit. ISA devices employ a technology that uses global positioning systems to limit the velocity of a moving vehicle to the posted speed limit, for example, or some other preset speed. Some ISA devices are programmed to include an override function to allow the vehicle to exceed the preset limit for the purposes of passing slow-moving vehicles or other conditions. Now about the bill. A person who has had their driver's license suspended for certain reasons is eligible for an intelligent speed restricted driver's license, a new type of restricted driver's license. To be eligible, the person must have had their driver's license suspended for an accumulation of moving violations in which at least one of the violations was for excessive speeding, defined as traveling at 20 miles per hour or more above the speed limit, or for a conviction of reckless driving that also included a finding that the person was guilty of racing. To apply for the new type of license, the person must apply to the department, pay a fee of $100, and provide proof that an ISA device has been installed in all the vehicles that the person operates, except on certain vehicles owned by the person's employer. The license requires a person to operate a vehicle to no more than the posted speed limit, but an exception is provided to allow the person to exceed the speed limit on up to 3 occasions per month for the purposes of passing slow-moving vehicles. The applicant for a new restricted license must demonstrate proof of financial responsibility for the vehicle operation. The new restricted license is effective until the person's driver's license suspension is lifted, and the department must require the person to maintain the device on all vehicles that the person operates for the duration of the suspension. The director of the department may cancel the new restricted license for good cause. The ISA device must employ a technology that uses GPS and be programmed to limit the operation of the vehicles to no more than the speed limit generally. The ISA device must include an override function that allows the operator to exceed the speed limit on up to 3 occasions per month. The person who is required to use an ISA device must pay for the costs of installing, removing, and leasing the device, as well as an additional fee of $21 per month. The department must deposit the additional fee to a new account established to offset the costs of the ISA devices for indigent persons. Following a suspension for an accumulation of moving violations in which at least one of the violations was for excessive speeding, a person may not operate a vehicle without a properly functioning ISA device for the first 120 days of the probation period. A violation of this requirement is a traffic infraction. Following a suspension for a conviction of reckless driving that also included a finding that the person was guilty of racing, the department must establish a period of probation for 150 days and require the use of an ISA device during that time. A violation of this requirement is a traffic infraction that triggers an additional 30-day suspension of the person's driver's license. In either case, where an ISA device is required, the person is otherwise required to operate a motor vehicle in a safe and lawful manner at all times, and the obligation to use the ISA device is not a defense or mitigating circumstance to any violation of the rules of the road. To be eligible to install, repair, maintain, monitor, or remove an ISA device, a person must apply to the department. An applicant seeking to install the device must submit a declaration that the device meets the definition as provided by the bill. And to maintain eligibility, a person must submit criminal background checks results to the department for any individual that is hired to install, repair, maintain, monitor, or repair the device. A person who violates the term of the new restricted license is guilty of a gross misdemeanor. A person who is required to use the device and tampers with the device or directs another person to tamper with the device is guilty of a gross misdemeanor. Another person who knowingly assists a person who is required to use one of these devices with the tampering of the device is guilty of a gross misdemeanor. A court of limited jurisdiction, and that's an error in the bill analysis, I think. It should be courts, both superior courts and courts of limited jurisdiction, may order the use of an ISA device with respect to a criminal offense as either a condition of pre-trial release of the defendant or of post-conviction probation when the court finds that the person engaged in excessive speeding, as defined in the bill. The provisions concerning the new restricted license and to the ISA device requirements do not apply to violations relating to the operation of a commercial motor vehicle. And the bill is effective January 1 of next year, and we have a fiscal note if you'd like to hear.
Yes, let's hear the fiscal note.
Sandy Meyer, staff to the committee. The fiscal note is available for this bill. It is a multi-agency fiscal note. The Office of the State Treasurer indicated an indeterminate impact, but the narrative indicated that the workload created by this bill could be completed within current practices and resources. The revenue impacts are also listed as indeterminate. Washington State Patrol has listed one-time cost impacts in fiscal year 26 of $76,000, $73,000 as the Transportation Committee, $3,000 as General Fund State. The fiscal impact is for the additional training to be developed and provided to commissioned officers and cadets. The Department of Licensing has listed a fiscal impact of 2.4 FTEs and $4,468,000 in the 25-27 biennium, with ongoing costs in the 27-29 and subsequent biennia of 2.4 FTEs and $600,000. 2.2 of the FTEs is for the additional number of applications that will be processed for this new restricted license, as well as applications for financial assistance. 0.2 of the FTE is related to the establishment of the new revolving account. $3,880,000 is for the updates to the Drives Information Technology System for this new program, with ongoing costs at $10,700 per year. DOL has also listed an indeterminate revenue impact.